What is the difference between wills and living trusts for seniors? Imagine planning your future and wanting to make sure your wishes are clear and your loved ones are taken care of. That's where wills and living trusts come into play. Both are tools to help manage your assets, but they work quite differently. Understanding these differences can make a big difference in how your estate is handled and how much control you have during your lifetime. A will is a legal document that states how you want your property distributed after you pass away. It allows you to name an executor who will oversee the process, and guardians if you have minor children. Wills only take effect after your death and must go through a court process called probate. Probate can be slow, sometimes taking months or even years, and it is a public process, meaning anyone can see the details of your estate. It can also be costly because court fees and legal expenses add up. A living trust is a different kind of legal arrangement. You, as the grantor, place your assets into the trust while you are alive. You can also serve as the trustee, keeping control over your assets. When you become unable to manage your affairs or after you pass away, a successor trustee takes over and manages or distributes the assets according to your instructions. And like a will, a living trust does not go through probate, which means your assets can be transferred more quickly and privately. One key difference is timing. A will only works after death, while a living trust can be used during your lifetime if you become incapacitated. This makes a living trust a helpful tool for managing your finances if you are unable to do so yourself. Wills are easier and less expensive to set up initially, but they do not offer the same protection during your life. To make a living trust work, you need to transfer your assets into the trust. This can include bank accounts, real estate, investments, and other property. If you forget to transfer an asset, it will have to go through probate after your death, just like a will. Wills are simpler and cover assets that are in your name at the time of your death. For seniors with larger estates or complex assets, a living trust can help avoid probate and keep your affairs private. It also provides a way to manage your assets if you become unable to handle your finances. Smaller estates or simpler needs might only requiring a will, which is less costly upfront. Many seniors choose to use both tools together, with a pour-over will that catches any assets not transferred into the trust. In elder law, the choice between a will and a living trust depends on your personal situation, goals, and how much protection and convenience you want. Both options can be tailored to fit your needs, giving you peace of mind and making things easier for your family down the road.